I ask you about Free Enterprise Fund in particular? Because Judge Lee, in the opinion in the Ninth Circuit, really tried to carefully parse Elgin and Free Enterprise Fund. What do you do with the part of Free Enterprise Fund that emphasized the fact that it was at the investigation stage and that would be the only way, therefore there would be no way ever to get judicial review of the claim at issue there? I guess it's the one paragraph on 490 of Free Enterprise Fund. How do you think we should deal with that?
Well, I think you should deal with it by sort of applying it here and saying actually it's on all fours with that situation. I mean, obviously, in Free Enterprise, because of the structure there, you had the unique sort of dynamic that, you know, there was a complaint about the board's activity and the review mechanism dealt with the commission's activity. But with respect to the idea that the only real way you could get review for the here and now injury that the Free Enterprise Fund was suffering was to sort of precipitate a contempt sanction and go to court immediately, that's exactly our situation. Our beef here isn't limited to the cease and desist order. We've been trying for years to get out of the FTC process. We've even offered to walk away from the transaction. So we think just being subjected to their processes as currently structured is our injury. The only way we could try to get that remedied is exactly what the situation was in Free Enterprise Fund. We could try to resist any cooperation with the FTC, sort of get ourselves in contempt and see if they did something to bring us to federal court. But this court has said you don't have to bet the farm in that kind of way.
In your distinction of Elgin, I want to explore briefly. So if you were bringing a claim challenging the constitutionality of the statute that was being investigated or the basis for the investigation/enforcement action, you couldn't, or what's your answer to whether you could bring a challenge like that in district court?
Well, maybe the easier way is to just articulate how I would distinguish Elgin, and then maybe if that doesn't answer your question, I'm happy to respond. But to me, the critical thing in Elgin was the party was challenging the very government action that the review mechanism was set up to provide a special avenue for review. So it was the challenge to adverse major employment action. And what the court held, I think correctly, is it doesn't matter what your theory is. It can be a cross-cutting constitutional theory, but if you're challenging the exact same adverse major employment action, you have to go through the process. So if we waited till the very end of this process and challenged the cease and desist order, I think then we'd be in all fours with Elgin. And I actually think no matter what our theory was at that point, we'd have to bring it in the Court of Appeals. We couldn't, at that late stage, challenge the cease and desist order itself in district court. But to me, that's the way to distinguish Elgin.
And then one last one. What's your exact formulation of the rule? So a challenge to the structure of the agency, I think, is covered. Anything beyond that? So
I would start with Judge Bumate's formulation that it's structure, existence, and procedures.
So let me stop you there. Procedures concerns me because I think that could be wildly open-ended and present some of the problems that the Chief Justice and others were pointing out. So
It concerns me as well, which is why I was about to say by procedures, I think he meant the kind of cross-cutting procedures that don't turn on the circumstances of any particular case. And I think that that actually explains some of the pre-Thunder Basin cases like McNary and Matthews v. Eldridge. But I did want to add one important point. That describes the basic universe of situations that you're dealing with, these kind of like specialized appellate court review regimes. But there are other situations where you get into district court under 1331 despite the government making a Thunder Basin argument. And a great example of that is the first Sackett case back in 2012, because there you had a situation where the government, relying on Thunder Basin, was telling the citizen, hey, wait, you can't get into court to challenge this determination. You have to wait until we bring an enforcement action. And this court rejected that argument and said, no, the citizen gets into court under 1331. So I think the formulation with that slight amendment that Judge Bumate had is the right one for this class of cases.